and offer the greatest degree of protection to individuals in Syria, pending the outcome of this case. The provisional measures requested are linked to the rights at issue in these proceedings. The applicants are also requesting measures that aim at ensuring the integrity of the proceedings before the court and the sound administration of justice. The first provisional measure requested is for Syria to take effective measures to cease and prevent all acts that amount to or contribute to torture and other cruel, inhuman, or degrading treatment or punishment. This measure directs Syria to do what it is fundamentally obligated to do under the Convention Against Torture, but has consistently failed to do, and cannot be relied upon to do without the court's intercession. In their application, the request for provisional measures, the applicants describe the acts that amount to or contribute to torture and other ill treatment, which are carried out systematically by Syrian officials across its system of detention, and include subjecting individuals to sexual and gender-based violence, enforced disappearances, and inhuman conditions of detention. The second provisional measure outlines a series of 4 concrete actions to eliminate or mitigate the substantially enhanced risk posed to detainees of being subjected to torture and other cruel, inhuman, or degrading treatment or punishment. They target circumstances of extreme vulnerability in detention, which are inherently conducive to torture and other ill treatment. An order to perform these actions would require Syria to comply with its obligations to take effective measures to prevent torture and other ill treatment. The first specific action is for Syria to cease immediately its practice of arbitrary detention and release all persons who are arbitrarily or unlawfully detained. Arbitrary or unlawful detention occurs when an individual is arrested or detained without a sufficient legal basis for depriving them of their liberty or without due process protections. The practice of arbitrary detention is particularly pertinent in the present circumstances, as arbitrary detention increases the risk of further human rights violations, including torture and other ill treatment. Within Syria, persons expressing dissenting views or who are otherwise perceived to oppose the government are habitually victims of arbitrary detention. Arbitrary detention, together with torture and other ill treatment, has been documented consistently by the Commission of Inquiry in its 12 years of investigating violations of international law in Syria. The release of persons who are arbitrarily detained in Syria by Syrian officials and halting of the practice altogether will reduce substantially the risk to individuals of torture and other ill treatment. The second action targets Syria's use of incommunicado detention. This practice creates situations of unique vulnerability, engendering a sense of extreme powerlessness and helplessness, as victims are isolated from the outside world, often without knowing where or how long they will be held. It also has extremely harmful effects on the loved ones of incommunicado detainees. Incommunicado detention and enforced disappearance markedly increases the danger that individuals will be subject to additional instances of torture and other ill treatment, as victims are placed beyond the protection of the law. With no visitation or communication possible with those held in incommunicado, no one is able to monitor independently the conditions of detention or the welfare of the detainees. Frequently, incommunicado detention amounts to ill treatment or torture in and of itself, given the harm and suffering inflicted on the victim and their loved ones. Ceasing incommunicado detention will thus halt the commission of certain instances of torture and other ill treatment. The third action requires Syria to provide access to places of detention by, in particular, international independent monitoring mechanisms and medical personnel, and to facilitate contact between detainees and their families and legal counsel. Regular contact with family members, legal counsel, and medical personnel has positive implications for the physical and mental well-being of detainees. Recurring access to detention facilities by external actors also has a powerful deterrent effect on the practice of torture and other ill treatment. Although Syria has previously allowed some international monitors to visit places of detention, these have excluded facilities operated by Syrian intelligence and security services. Yet it is precisely these facilities that are among the most notorious for torture and other ill treatment. Accordingly, the applicant's request specifies that independent monitoring mechanisms must be able to access all official and unofficial places of detention. The fourth action is for Syria to immediately take urgent measures to improve the conditions of all its official and unofficial detention facilities in accordance with international standards. As Canada and the Netherlands set out in their application, the abhorrent conditions documented across Syria's system of detention amount to ill treatment or even torture. Inhumane and unhygienic conditions marked by severe overcrowding, deprivation of food and potable water, and lack of access to medical care place the lives of vast numbers of detainees in jeopardy. Disease, dehydration, malnourishment, and denial of medical care in Syrian detention facilities have already claimed the lives of victims on a massive and alarming scale. The spread of illness and infection, including from easily preventable conditions, is rampant in many facilities. Detainees suffering physical and psychological injuries resulting from torture and other ill treatment, as well as those in fragile health, are in urgent need of access to medical care. The substandard state of Syrian detention facilities is not a question of lack of capacity of resources. To quote the report issued by the Commission of Inquiry on the 10th of July 2023, the fact that the conditions of detention are not as poor in civilian prisons, according to the former detainees the Commission has interviewed, shows that the state has the necessary capacity to provide for adequate conditions of detention, but chooses not to do so in the intelligence directorate detention or in military prisons. End of quote. The conditions in Syrian detention facilities are so poor as to violate even the most fundamental baselines set out in international law for the humane detention of persons and the prevention of torture and other ill treatment. Madam President, with the third provisional measure, Canada and the Netherlands seek to preserve the evidentiary record of the case by requesting that the court direct Syria not to destroy or render inaccessible any evidence related to the application. The request includes the preservation of, without limitation, medical or other records documenting injuries sustained due to torture or other ill treatment, or the remains of any victim of torture or other ill treatment. This third provisional measure, together with the sixth and seventh measures, which I will come to shortly, are requested with the intention of protecting the integrity of the proceedings pending the final decision of the court. The court has recently issued a similar order for the preservation of evidence in the case of the Gambia and Myanmar, as in those circumstances where the acts complained of took place in the territory of the respondent state, the violations of the Convention Against Torture have been committed in Syria, which has primary control over substantial first-hand evidence relevant to these proceedings. Similarly, the applicants request the court to direct Syria to preserve any relevant evidence to ensure that the court is properly equipped to assess the merits of the case, as well as the fair adjudication of the applicant's claim. Madam President, I now turn to the fourth and fifth requested measures, which seek to address the devastating impact of missing persons in Syria. The fate or whereabouts of tens of thousands of detainees in Syria remains unknown. Some at this moment are being held incommunicado or otherwise being subjected to torture or other ill treatment. The immediacy of the need for Syria to cease this practice is reflected in the decision of the United Nations General Assembly to establish the independent institution on missing persons in the Syrian Arab Republic on the 29th of June 2023. Thousands of individuals in Syria are believed to have died as a result of torture or other ill treatment in custody. Despite keeping meticulous records on its detainee population, Syria chooses to prolong the suffering of the families and loved ones by withholding information or obfuscating the truth about the circumstances of detainees' disappearance or death. Tens of thousands of families have been shattered and continue to suffer needlessly, not knowing where their loved ones have died, and if so, how they perished or what happened to their bodies. They can neither mourn nor process their loss. The commensurate fear and the mental anguish makes entire families the victims of enforced disappearances, and the resulting impact can itself constitute torture or other ill treatment. The paralyzing uncertainty for families also creates serious practical challenges. Without an official death certificate, next of kin cannot access social benefits or other government services. Women are particularly disadvantaged and unable to effectively exercise land, property, and inheritance rights. When death certificates for victims are issued, Syrian officials attempt to conceal their brutality by falsely recording the cause of death as heart attack, stroke, or simply an unknown cause. For these reasons, Canada and the Netherlands request that the court order Syria to safeguard any information concerning the custodial death of victims for the duration of these proceedings. This includes conserving forensic examination of human remains or the burial locations of victims. Not only does this information form part of the evidentiary record, which must be preserved to ensure the integrity of the present proceedings, but its retention is required for Syria to comply with its obligation to promptly and impartially investigate allegations of torture and other ill treatment, including those resulting in custodial deaths. Furthermore, we have requested that Syria be directed to provide next of kin with death certificates, which record the true cause of death of any victim who died in Syrian custody, and to disclose the location of the burial sites of persons who were victims of torture and other ill treatment. According to Commission of Inquiry reporting, tens of thousands of individuals who have died in government custody are believed to be buried in mass graves in Syria. These measures, if ordered, would again require Syria to perform its obligations to take effective measures to prevent as well as to investigate acts of torture and other ill treatment, consistent with Articles 2 and 12 of the Convention Against Torture. The families and loved ones of missing persons in Syria have been desperately seeking answers for far too long, at a severe cost to their mental and physical well-being.
Madam President, we shall now turn to the sixth provisional measure in which Canada and the Netherlands request that the court enjoins Syria from taking any action that might aggravate or prolong the dispute or complicate its resolution. The court has already issued similar guidelines, notably in the recent cases of Armenia versus Azerbaijan and Ukraine versus Russia, concerning the Genocide Convention, where it has ordered the parties to refrain from any action that might aggravate or extend the dispute before the court or render its settlement more difficult. Syria continues to perpetrate acts of torture and other unlawful treatment, which obviously aggravate the dispute before the court. With each of these acts, Syria continues to violate its obligations under the Convention Against Torture, and the number of victims suffering irreparable harm continues to increase inexcusably. This demonstrates not only the urgency of the situation, but also the need to protect the integrity of the proceedings before the court and the applicant's right to a fair hearing. As the seventh measure, Canada and the Netherlands request the court to order Syria to report regularly to the court on all measures taken to give effect to its order for provisional measures.
Article 78 of the Rules of the Court provides that the court may request information from the parties on any matter related to the implementation of any provisional measures it has indicated. And recently, in Gambia versus Myanmar, the court deemed it appropriate to order regular reports accompanied by precise deadlines. The continuous nature of serious violations and the substantial risk of violence and bodily harm of persons arrested, detained, or imprisoned also justifies a clear and continuous obligation for Syria to provide reports so as to monitor Syria's compliance with any provisional measure ordered by the court. The obligation to report is also necessary considering Syria's total lack of cooperation with the mechanisms of the United Nations international law. Furthermore, Syria did not fulfill its obligations with respect to accountability to the Committee Against Torture, which is the treaty body in charge of monitoring the execution of the convention. Syria also defied the request made by the committee in November 2011 to submit a special report on concerns pertaining to brutal repression of demonstrations by Syria. In its final observations in 2012, published in the absence of a special report, the committee expressed its serious concerns about, and I quote, the habitual use of torture and cruel and inhuman treatment as a tool which appears to be deliberate and part of states' policy to instill fear and to intimidate and terrorize civilian populations, and the complete disregard by state party authorities of the requests from authoritative international bodies and experts to seize these violations. End of quote. More than a decade later, the observation made by the committee is still just as valid. The request for accountability is therefore compatible with maintaining the integrity of the present proceedings. The practical effect of this measure is also to prevent non-compliance and repeated breaches that are likely to aggravate the proceedings. Given that all states parties to the Convention Against Torture have a common interest in Syria's performance of its obligations under the Convention, it would be in the interest of good administration of justice for Syria to make its reports publicly available. Furthermore, we request that a reasonable time frame be afforded to us so as to enable us to respond to these reports.
Madam President, honourable judges, as a new eighth measure, Canada and the Netherlands respectfully request that the court requires Syria to take several immediate steps to reduce the risk of torture being committed by its officials and others within the system of detention. This includes issuing instructions to all those involved in the detention system, checkpoints and hospitals to ensure that detainees are treated in accordance with their inherent human dignity. They should also receive information and training on the prohibition against torture in accordance with Syria's obligation under Article 10 of the Convention Against Torture. In addition, in order to prevent further commission of torture and other ill treatment with the utmost urgency, Syria should immediately suspend all personnel suspected of having committed torture or other ill treatment. This will have the important effect of preventing repeat offences by these officials, pending Syria's fulfilment of its obligation to conduct investigations into such wrongdoings. Finally, the court is requested to require Syria to lift de facto immunity granted for those of its officials who commit torture, and to direct its officials not to use any statement obtained under torture as evidence in any proceedings, including and in particular for crimes which the death penalty can be imposed. Madam President, as the agent for the Netherlands has noted, Syria's decision not to participate in today's proceedings does not shield it from the court's directives. As the court has previously found, orders on provisional measures under Article 41 of the statute have a binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. Madam President, distinguished members of the Court, as the Commission of Inquiry has previously observed, Syria's treatment of detainees represents a national trauma that will affect Syrian society for decades to come. Justice and accountability are crucial to breaking the cycle of violence and atrocities, and are important as a step towards building a sustainable peace in Syria. It is this imperative that brings Canada and the Netherlands before the court today to seek the court's indication of provisional measures to ensure Syria's compliance with its obligations under the Convention Against Torture. Detainees currently in custody in Syria are at imminent risk of death or severe physical or mental harm. Anyone in Syria who may be detained in future faces the same immediate risk. Over a decade of inaction has shown that Syria cannot be relied on to refrain on its own volition and without a binding order from the court, from inflicting heinous acts of torture and other ill treatment against its population. This is why we have requested the court to indicate provisional measures. Thousands of persons in Syria remain in custody, and urgent action is needed to prevent further deaths and needless suffering. The provisional measures requested by Canada and the Netherlands are practical, realistic, and consistent with the protections offered by the court in its previous orders indicating provisional measures. They are necessarily comprehensive in order to preserve the rights at issue in the case, which are quite literally a matter of life and death. It now rests with this court to take action. Since Syria has chosen not to appear, we anticipate that this will be the last statement made by Canada and the Netherlands at this hearing. With your permission, Madam President, and in accordance with Article 60 of the Rules of Court, I shall now read out the applicant's final submissions. The applicants, as states parties to the Convention Against Torture, respectfully request that the Court, as a matter of urgency, indicate the following provisional measures which are directly linked to the rights that form the subject matter of the dispute, pending its determination of the case on the merits. A. Syria shall immediately take effective measures to cease and prevent all acts that amount to or contribute to torture and other cruel, inhuman, or degrading treatment or punishment. B. In light of the greatly enhanced risk for detainees of being subjected to torture and other cruel, inhuman, or degrading treatment or punishment, Syria shall immediately, 1. Cease arbitrary detention and release all persons who are arbitrarily or unlawfully detained. 2. Cease all forms of incommunicado detention. 3. Allow access to all of its official and unofficial places of detention by independent monitoring mechanisms and medical personnel, and allow contact and visitations between detainees and their families and legal counsel. And 4. Take urgent measures to improve the conditions of all of its official and unofficial detention facilities to ensure all detainees are treated with humanity and with respect for the inherent dignity of the human person in accordance with international standards. C. Syria shall not destroy or render inaccessible any evidence related to the application, including without limitation, by destroying or rendering inaccessible medical or other records of injuries sustained as a result of torture or other cruel, inhuman, or degrading treatment or punishment, or the remains of any person who was a victim of torture or other cruel, inhuman, or degrading treatment or punishment. D. Syria shall safeguard any information concerning the cause of death of any detainee who died while in detention or while hospitalized, including forensic examination of the human remains and places of burial, as well as afford the next of kin of any person who died as a result of torture or other cruel, inhuman, or degrading treatment or punishment following arrest, hospitalization, or detention, with a death certificate stating the true cause of death. E. Syria shall disclose the location of the burial sites of persons who died as a result of torture or other cruel, inhuman, or degrading treatment or punishment following arrest, hospitalization, or detention to the next of kin. F. Syria shall not take any action and shall ensure that no action is taken which may aggravate or extend the existing dispute that is the subject of the application or render it more difficult to resolve. G. Syria shall provide a report to the court on all measures taken to give effect to its order for provisional measures, beginning no later than 6 months from its issuance and every 6 months thereafter, pending the resolution of the dispute. And H. Syria shall take immediate actions to reduce the risk of torture being committed by its officials and other personnel, including by issuing instructions to ensure that detainees are treated in accordance with their human dignity, suspending all personnel suspected of having committed torture or other ill treatment pending investigation, lifting de facto immunity for those of its officials who commit torture, and ensuring that statements obtained under torture are not used as evidence in any proceedings. Madam President, distinguished members of the Court, this concludes Canada and the Netherlands' oral observations. On behalf of the applicants, I wish to thank you for your kind consideration.
I thank the Agent of Canada for his statement, which brings to a close this single sitting. Let me thank the agents, counsel, and advocates of the applicants for their assistance in the course of this hearing. In accordance with usual practice, I would ask the agents of Canada and the Netherlands to remain at the Court's disposal to provide any additional information the Court may require. The Court will render its order on the request for the indication of provisional measures as soon as possible. The parties will be advised in due course as to the date on which the Court will deliver its order in a public sitting. Since the Court has no other business before it today, the sitting is declared closed.
يمكنكم مشاهدة برامجنا ونشراتنا الإخبارية على قناة راديو وتلفزيون الكل على اليوتيوب، ولا تنسوا الاشتراك وتفعيل الجرس ليصلكم كل جديد. ابقوا على اطلاع دائم ببرامجنا ونشراتنا الإخبارية. راديو وتلفزيون الكل.
في كل ما يدور حولنا من وقائع تبدو في ظاهرها سلبية، في كل التجارب التي نخوضها ونعتقد أننا فشلنا، وفي كل النتائج التي توحي لنا بالخسارات، ننظر إلى النصف الممتلئ بعين المتفائل الذي لا يعرف اليأس ويمتلك إرادة التغيير. برنامج النصف الممتلئ، نظرة إيجابية من وحي الواقع، يأتيكم من الأحد للخميس 6 مساءً.